Hey guys, welcome back to another week of Mortgage Matters in Minutes. Again, I'm your host, Brent Rasmussen, owner of Mortgage Specialists. As some of you are checking into this video, it might feel very complicated to talk about the words mortgage and trust and deed of trust and beneficiaries and trustees and all the others, but we're going to keep it as simple as we can here today to understand a few basic questions people have when they understand they have a trust and they want protection with that and obtaining a mortgage. So this week is our 135th episode, and we want to say thank you all for tuning in, checking us out. Continue to like and subscribe below. It's the summer months. We hope you're enjoying it at this point in time, as here in Omaha, it's about as hot as it comes. So today's question is, can I put my mortgage in a trust? So let's talk a little bit about that, and talk about first, what a trust is. A trust basically is a legal document that a party known as a trustee holds and manages assets for another party, such as the beneficiary. So that's what a trust is. That's really complicated, but generally, what we want to know is there's different kinds of trusts that are out there: revocable, irrevocable. And the common reason people set those up is to protect assets, protect themselves from liability, possibly, of people knowing what they own, and knowing where they live. But mainly, people use them for estate planning reasons, to not pay taxes or to avoid situations of generational wealth. A lot of different reasons. We're not going to get into all those. But generally, when people call us and clients call us, they want to put the mortgage themselves in the trust. So let's talk about that as an example. For the type of mortgages that we do, they're all going to be, again, set by the secondary market, which we've talked about many times, as Fannie Mae, Freddie Mac, FHA, VA, and USDA are the types of loans that exist. All of those underwriting rules are not allow the trust itself to be the borrower. You, as the person, the individual, has to be the borrower. But can you put who owns the house into the trust? Yes, you can do that. And we're going to talk a little bit more about that. So we also get this question a lot: can I put the mortgage in my business's name? So we ask, do you want the loan to be in the business name or the ownership of the house to be in the business name? Again, the loans for mortgages are only going to be done in the person or borrower's individual's names. They're not going to do the loan in the business name. If you want a business loan, we send you over to a business lender. That's what they do, is commercial lending, not residential lending. Then they'll look at whether the business has enough assets, income to qualify on its own, or they need you to personally guarantee. So all residential loans nearly are going to require a personal guarantee. So what's the real saga here? Again, what comes up is some attorneys contact us and state, hey, if I move the ownership of the property from person A and B's name into a trust, the deed of trust states that that could be a due on sale clause, which basically means if the ownership of the property transfers to someone else, like in a sale, or you give your property to someone else, that can cue the due on sale clause. So let's back up a little bit and say, what's a due on sale clause? Basically, if you own a property and you had a $100,000 loan on it, and you said, I don't want to own this property anymore, and you give it to your next door neighbor, that lender is going to care that you still have a $100,000 loan and you need to pay that loan off because you now relinquished your ownership of that property. So that's what a lot of times people are scared about when they're transferring residential loans into a trust. But the scenario exists when you do go about doing that, which you can transfer, change title and ownership all the time. I would highly, highly, highly suggest, I can't say highly enough, to contact a CPA, an estate planning attorney, financial advisor, and or a mortgage person before you do this, to make sure there's not tax implications, financial implications that can happen to you. And we see this happen often where family members state, when I pass away, I don't want my house being gone, so I'm going to put my daughter's name on the deed of trust, or on the trust, or I'm going to transfer ownership to my son's name. that can cause a lot of different issues. So before you file what's called a quitclaim deed, and a quitclaim deed can transfer ownership, it's a very easy document to do, but please, before you go find a quitclaim deed and you do this, consult professionals, because there's lots of financial laws, rules, and regulations that can cause more harm by you doing that than not enough. So let's back up a little bit and talk about that due on sale clause. And while that is a normal question, when it comes to the residential loans that we do, we have the Jarn St. Germain Act of 1982 to look back on, which basically states if you transfer the ownership of your own home into a trust that as an inter vivos living trust, which you remain the beneficiary of, it doesn't consider that to be a due on sale clause. Your family can continue, if you pass, to make those payments for you and can still continue to keep that loan for as long as needed. And also, you may not need to refinance that loan, and you can add other family members to the property without there being a due on sale clause. So if you ever get concerned about transferring the property due to what kind of loan you have, obviously refer to the Garn St. Germain Act of 1982 and look at the summary points there to make sure you're covered in regards of transferring over the ownership of your house to your irrevocable living trust. Because that is something we see happen each and every day and is totally okay. I can't guarantee and say that's the fact if you go out and get a commercial loan or a loan that's in-house at a particular lending institution, but this law states on behalf of the loans to the secondary market that you are protected in those steps that can happen. So again, what's the benefit of doing this? It's for protection. It's for asset protection, estate planning protection, and also possibly, knowing what assets you own and where you might possibly live. So hopefully we kept this very simple today. If you like this information, please like and subscribe. Check us out each and every week as we're working to give you accurate, simple, short answers to mortgage and real estate information that can help you hopefully answer a few questions throughout the process if you're looking at buying or selling real estate in regards to mortgage needs. I'm Brent Rasmussen of Mortgage Specialist. Feel free to call us anytime at 402-991-5153 or check us out on our website at mtg-specialist.com. We'll see you all here next week. Have a great rest of your week. Mortgage Specialists. Driven, trusted, reliable.